Well, welcome everyone to today's webinar and to the Morning Blend. I'm Alison DiFlorio, and I'm so thrilled to have back with me once again, after many years of doing this webinar, our partner, Lori Armstrong from Fox Rothschild. Hi, Lori.
Hi, Allison. How are you today?
Great, great. Always good to see you. And for those of you that are joining us for the first time, welcome. And for those of you who have attended a morning blend before, welcome back. This, as many of you may know, is a chance to share some updates from the HR space and from the legal space on issues that may be impacting our business community. So we look forward to sharing some of the latest and greatest topics with you today. Just as a housekeeping tip, this is being recorded, and we will be sending a link out after the session. So if there's someone that you know that may benefit from the information, please share that with them. Your phones are muted. Your questions are important. So please use the QA feature to type in any question that you may have. Lori and I will do our best to address them. If we can't, our contact information is at the end on the last slide, and we welcome your questions. And I think that's all the housekeeping tips. And I think we're ready to move into our agenda for today. Before we do that, just a couple of formal introductions. Again, some of you may already know us. As I mentioned, I'm the managing partner of Exude Human Capital. Exude Human Capital is a consulting firm with areas of expertise in human resources, diversity, equity, inclusion, belongingness, and leadership development. And we serve both the for-profit and nonprofit sectors and really focus on all things people. And I hope to share with you today some of the trends that we're seeing and what our clients are asking about. And I'll turn it over to Lori.
Well, thank you. For those of you we've not spent time together in the past, I have been practicing in the space of workplace law for almost 30 years. In my spare time, I corrupt young legal minds at Temple Law School, where I've actually just created a new course I'm very excited about. Allison, I might rope you into being a guest speaker.
Oh, I'd love that.
But we're going to build a company in the spring semester, and in that context, explore various aspects of both traditional labor law and employment law, like, writing a handbook, what kind of policies would we need, and discrimination claims, and, oh my gosh, my company wants to unionize, how does that work? So I really enjoy that. And then I'm also a volunteer mediator in the EEOC's ADR program, which I've been doing for several years. So lots of fun things. Just a brief note about Fox. We are a full service firm all around the country with lots of different services to provide, from corporate to litigation to bankruptcy to family law and trust and estates. And I appreciate the support of the firm in partnering here to do this.
Great. And we appreciate your time because I know you're busy, and we always appreciate you joining us for these webinars. So what do we have going on today? Piping hot. We've got the Loper Bright decision that Lori's going to enlighten you on. And we'll be talking a bit about non-competes. I know that a number of our clients have been asking about those recently. And for our daily brew, in case you haven't heard, we have elections coming up in about 28 days, and that may create some issues in the workplace. So we're going to talk about some things you can talk about navigating political conversations in the workplace, and any potential issues that may arise. So let's kick it off with Lori and a legal update.
All right. So Loper Bright, boy, that sounds like a really exciting case, doesn't it? I'm going to spend a very little bit of time that I think it's an important case. And for lawyers in particular, we're like, what the heck is going on? The sky is falling. But I'm going to remind you all, some of you of a certain age will remember Schoolhouse Rock and learning about the different branches of government. So we're going to have a Schoolhouse Rock moment, and then I will explain why this case is important, particularly in the context of labor and employment. So as you may recall from I'm Just a Bill and other cartoons on Saturday mornings, there are three branches of government, and the congressional branch is the legislative branch, or I should have said that the other way, but Congress is the branch that makes laws. The executive branch is the branch that interprets and enforces those laws, and then the judiciary, well, this is sort of the issue in Loper Bright. The judiciary is supposed to also enforce the laws, but in a different context, right? They're supposed to look out for constitutional challenges, et cetera. So for as long as I have been practicing, there was a what we call deference to agencies, and that's under this Chevron case from 1984. And in that case, the Supreme Court held that courts should defer to the agency who is charged with interpreting or enforcing the law, and it should defer to what they believe is the correct interpretation or enforcement of that law. So, for example, the EEOC is the enforcement agency for Title VII and other anti-discrimination statutes. So when the EEOC puts forth guidance or rules, and you might remember or might have been familiar with rulemaking, where they will propose a rule and then you have some period of time where lots of people provide comments, and then they enact a final rule, which is what the non-compete situation is about. And then that becomes, or at least we thought, sort of the law of the land for how the law is supposed to be interpreted, and with the same level of sort of deference to that agency rule. Well, that's not the case anymore. Loper Bright has rejected 40 years of precedence and rejected this presumption of agency expertise, reasoning that if there's any question about what the statute really means, that is up to the court to decide, not the agency. So why do we care? Well, if there is a challenge to an EEOC interpretation of Title VII, for example, you might have the U.S. District Court for the Eastern District of Pennsylvania determine that the statute should be interpreted one way, but the U.S. District Court for the District of New Jersey across the river might interpret it differently. And so I think there are a lot of lawyers and HR professionals out there going, well, what does this mean? Do we have to listen to the agencies anymore? Are they still the best arbiter of what's going on? And that does remain a bit up in the air. And you're going to see on the next slide exactly what we're talking about. So as you may recall, the FTC had announced a rule in April of 2024. It was a final rule. So it had gone through that rulemaking process where people were invited to comment. The agency took those comments under advisement and then enacted this final rule. And it was supposed to take effect on September 4th. And the rule would have banned non-competes for virtually any context. And that would have affected about 30 million workers who are currently subject to non-competes. The thinking behind the rule, remember, it's the Federal Trade Commission, right? So we're talking about fair trade and things like that. The idea behind the rule is that employers are unlawfully burdened, that non-competes are an unfair method of competition. And there were some exceptions in place. Well, guess what? Next slide. The rule is dead. On August 20th, 2024, a U.S. federal court in the Northern District of Texas set aside the non-compete rule and ordered that it shall not be enforced. The reasoning behind that came in line with the Loper Bright reasoning that the FTC had overstepped its authority, that it incorrectly interpreted the law. And although the order can be appealed to the Fifth Circuit, we haven't seen that happen yet. So as far as I know, at least as of last week, there had been no appeal, which I think means that the rule is dead at this point. But the FTC cannot enforce the rule against any employer nationwide at this time. Now, I put the note in here about the Loper Bright decision that we just talked about. That said, I'm going to talk a little bit about non-competes because there are, in fact, I have super breaking news that came out yesterday. I'm going to ask you to go back for 1 second. There are still aspects of non-competes that are hot and challenges to the enforcement of non-competes. The one thing I do want to say is, and I'm going to talk about the overtime rule in a couple minutes, but the Fifth Circuit is often where these sorts of challenges are made, and you see a lot of decisions out of the Fifth Circuit. I'm not going to get into detail because we really want to spend a lot of time on dealing with political speech in the workplace. But to the extent that we spoke about the pregnancy fairness workplace regs in our last session together, I did want to note that there were similar challenges on the same basis to the EEOC's rules that we talked about in April, or maybe it was June, whenever we were all together last. The rule had come out in April, and there are aspects of that rule that have been restricted in certain jurisdictions, but currently the rule in general remains in effect. So I think it's Mississippi and Louisiana. There are aspects of the rule relating to abortion services that have been enjoined, but only enjoined in those jurisdictions. So currently that rule remains in effect and although there are challenges pending, it is not enjoined and in the same way that the FTC rule is dead. Okay, so breaking news on this. Yesterday, the General Counsel of the NLRB issued a memo. And for those of you who have heard me talk in the past about her, the National Labor Relations Board is the agency that interprets the National Labor Relations Act. It is led by a board of 5 members, currently 4, 3 Democratic appointees, 1 Republican appointees, and that switches depending on which party controls the White House. But there has been a lot of pro-labor activity at the board in the past several years, as you've all heard me talk about. Well, Jennifer Abruzzo, who's the general counsel of the board, has been talking for a while about her belief that non-competes violate the National Labor Relations Act, and also things like tuition payback programs where you give somebody a bonus or some sort of payment so that they will get specialized training. And then if they leave in some period of time, you make them pay that back. Well, General Counsel Abruzzo thinks that those violate the National Labor Relations Act. I'm going to really kind of condense her reasoning, but the general belief is that for an employee, the ability to leave their employment and go somewhere else is the greatest expression of their Section 7 rights, their ability to object to terms and conditions of employment, to engage in concerted protected activity, et cetera. And these non-competes and tuition reimbursement programs and things like that unfairly restrict or impede on those Section 7 rights. So the memo is lower on the hierarchy than a statute and rules that we've just talked about, but it does set sort of the agenda for what you might see, because the general counsel will direct the regions to look for claims that have been filed. We call them unfair labor practice charges, challenging these, non-competes or the tuition payback programs, so that they can get those cases before an ALJ in the NLRB and maybe change the law that way. P.S., because I could talk about this all day because I find it really interesting. You might have seen, if you're a real law geek, that that there was a challenge to the SEC's internal judicial system and that their judges are unconstitutionally sort of ensconced within themselves. Similar challenges are being made about the way the board is currently structured, and that would put a wrench in General Counsel Abruzzo's plans. But I just want you to know that, and I've said this before, the NLRA applies to whether you're unionized or non-unionized, and this is an area where we don't normally go, oh, they would be involved in non-competes. Well, guess what? They are. And when we talk about political speech, we're going to have a similar conversation. The other thing you need to remember about non-competes, and now Alison's good probably to go forward, is that various states have their own restrictions. And this is a map from the Economic Information Group, and it just gives you some general information. I'm not going to get into all of the specifics, but for example, the very darkest ones like California, they have a ban. You can't have a non-compete in California at all. Some have income restrictions. So like the Northern Pacific states, you have to, the level of position in the company has to be sufficiently high for there to be non-compete protections that would be allowable. Some have other types of restrictions in terms of scope, timing, when they have to start, what type of consideration makes them enforceable. And then, for example, in Pennsylvania, there's no statutory restrictions, but courts will only enforce non-competes in Pennsylvania to the extent necessary to protect the employer's confidential, proprietary, and trade secret information. So if your non-compete in Pennsylvania is like, you can't work for anybody for a year, or no, you can't work for anybody for 5 years at all, the court's not going to uphold that because it's overly broad. If it's, you can't work for direct competitors or with respect to clients that you have serviced and it's only for a year or something like that, those are likely to be upheld in Pennsylvania. It's a very complicated area. I would urge you to be thoughtful about whether you really need a non-compete. Other protections might be better suited, like non-solicitation clauses. If you're concerned about people leaving and then taking your people, non-solicitation agreement might be better. A regular confidentiality or trade secret protections might be better suited for what you're trying to protect. And if you use them too broadly, they tend to be, that can be used against you when you're trying to enforce them, because again, it looks like you don't really know what your protectable interest is. You're just saying you can't, nobody can work anywhere after us for some period of time. So anything to add on that, Alison?
I have a question, because I would imagine some people are thinking, well, our company is based in Pennsylvania, but we have employees in California and in some of these other states that have state restrictions. How does that impact those organizations?
This is like a law school question. It's a great question. Generally speaking, an employee is going to assert that the law that applies, and they're likely going to be right, is the law of the land where they are working. So if you have a California-based employee, the California law will apply. I had a case probably 20 years ago now where I had a company and it was a non-compete case, a company in New Jersey had an employee in California, but they agreed in their employment agreement that any challenges to the employment agreement, which included a restrictive covenant, should be brought in New Jersey and subject to New Jersey laws and interpretation. The person filed a claim in California anyway. California said they had a public policy interest in protecting their statutory restrictions. And I don't remember at this point whether the statute was in effect or if it was just their general, the courts generally did not uphold them. And I honestly, at this point, cannot remember how that case turned out. But the point is, you should expect that wherever your employee is working, that you're going to be subject to the laws of that state or municipality.
And just to kind of build on that. So for people listening who are thinking about drafting handbooks and things like that, if they're in multiple states, is it best to say that look at the most, the broadest policy out there and kind of craft your policies to meet those expectations, and then by doing that, you're more likely to be covering the rest of the states as well?
Yeah, well, there's a couple ways to do it. It kind of depends. Oftentimes people do that with respect to like sick leave because they don't want a patchwork of sick leave or PTO policies. But you might have like an addendum or an appendix that applies specifically to employees in certain states, because there are things that you don't want or can't operationally accommodate across the country.
Right. All right. So this is a question, this question comes up all the time with clients, and I know that we've got a second increase on the horizon scheduled for January. Love to hear your thoughts on this.
Yeah, so interestingly, unlike the FTC's non-compete rule, on September 11th of this, so this is more like breaking news, the U.S. Court of Appeals for the Fifth Circuit ruled that the Department of Labor has the authority to use salary as a factor in determining who is eligible for overtime pay. So the rule that went into effect in April regarding the increase in salary for white collar employees remains in effect as we sit here today. That means, and I just want to give you a quick overview for anyone that hasn't been already addressing this. I want to remind you all that the default under the Fair Labor Standards Act is people must be paid at least minimum wage for their on an hourly basis, and need to be paid overtime for hours worked over 40 in a work week. There are exemptions to that requirement. So the idea is that the default is supposed to be you pay overtime, the exemptions are the exception. And so the exemptions, there are a couple of different types. There's a computer exemption, but the ones that we're really talking about are the white collar exemptions. Those are the professional, executive, administrative, and outside sales exemptions. And then there's also the highly compensated exemption. I'm going to talk about both briefly, but all of those exemptions that we're talking about, one of the requirements is that the employees are paid on a salary basis. That is, that they get paid the same amount regardless of the quantity and quality of their work in every week. So we can't track their hours. That they get paid this salary basis at the threshold that is set forth in the rule set forth by the Department of Labor, and that's what's going up, and that they meet the other requirements for the exemption, which generally have some sort of level of authority or discretion or use of business judgment. The supervisory exemption requires that you're supervising people. The administrative exemption requires that you're doing administrative supplemental work, not the actual work of the organization. So if you're in a factory, for example, and there's an executive assistant who's supporting the manager of the factory, she's not doing the factory work. She's doing administrative work in support of the factory. They're complicated. And we're not going to spend the time going through them all, but it's not as easy as they have to make X. Salary does not mean exempt. It is one of the criteria. So I know, Alison, we were talking before that some of the questions we get about the highly compensated folks have to do with, is it just that they make so much money that we don't have to think about it? It's not simply that. The highly compensated employee has to meet the test under Section 13A1 of the Act, which says that they have to earn total compensation that meets the requirements. Their primary duties must include performing office or non-manual work. They must customarily and regularly perform at least one of the exempt duties or responsibilities of either an executive, an administrative, or professional employee. So they must also meet that total compensation is one of the things. And then underneath that, there is also the requirement that they are making at least a certain salary as part of that whole bubble.
So total cash compensation is the high number, but there is that base number that they have to be making.
Yep. And so what does this mean? I mean, you may all remember maybe it was 8 years ago. I can't remember now, 4, 5, 6 years ago, when the Obama administration did this adjustment, and everybody was up in arms, and we were all scrambling around trying to do reverse engineering with the salary, and how are we going to pay people, and do we kick them into an overtime situation? And some people don't like that because they feel it's a diminution of their prestige in the organization. Well, at that time, that rule was challenged, it was enjoyed, and then it later went into effect, but with lower salary thresholds. This one's in effect, and so far as we can tell, is going to stay in effect. And so now that fire drill has been done, we're probably a little more comfortable with that reverse engineering and figuring out how to deal with the morale and other issues. But of course, Alison, I know you and your organization can help with that. We can certainly help with that. And I do urge you to take the opportunity from a legal perspective to engage counsel. And I'll tell you why I say engage counsel, and do an internal audit of your pay practices. Make sure people are classified appropriately. Make sure that they are being paid compliance with the various rules. And the reason I say you should do it with counsel is because then your audit, you can argue that it's privileged. And if you find bad things, you don't have to turn them over necessarily. But it also gives you an opportunity. The reason I say do this now is that because of all these changes, it gives you an opportunity to fix things in a less broadcast way than if you do it sort of in the middle of some random time period and you realize you have mistakes that you have to fix. I cannot stress enough. I have a slide somewhere that the top 10, and I can't remember the years, in the past couple of years, top 10 wage and hour cases were $45 million worth of revenue. So that meant that each case on average was well over 4 million. And I can do the math for you, but if you think about, we kind of think about, it's one person, it's $20 a week that we're wrong, right? Let's say $100 because it's easier. Well, $100 a week becomes how much, multiplied by 50 is 5,000. 3-year look back is 15,000. And if the court finds that you were willful, and that's not a difficult standard for them to find, now you owe 10,000 for one employee. And if you have 20 employees, now that becomes a lot more. And on top of that, you have to pay the plaintiff's counsel all of their fees. So a simple wage and hour mistake can be more costly than almost any other labor and employment legal error that you can make.
I would also add, in addition to what you've just shared and the importance of doing an audit at some point with legal counsel, that it's time to kind of step back and look at your entire comp structure. And periodically, you should be doing that. If you haven't done it in a while, we strongly recommend. We do a lot of work in this space and speak a lot on this. But you want to, if you're going to be making these adjustments, you need to look at the total organization and see what the impact is. And also occasionally look at the market and see where you are so that you can ensure that you're being competitive with the market in which you look for talent. So I know it's a scary space sometimes, and the numbers can really add up, but it's important work. And once you look at that structure and have it in place and strong, then you're just maintaining, puts you in a better defensible position.
Yeah.
Great. All right, so we're going to move on to the Daily Brew. Are you ready for the elections, everybody? I don't think any of you made it to this webinar without hearing, seeing, or listening to something about the elections, and your employees are facing same. We talk about this work-life integration and how, your commute is from your upstairs to your kitchen table, and in that short period of time, you're bombarded with information about the elections. And this is an emotional time for a lot of people. The election itself is contentious, but the issues that are at hand are very personal for people, and it evokes a lot of emotions. In fact, we had done a webinar on this topic a couple of weeks ago. And some of the data that we uncovered in prepping for that is that people experience conflict in the workplace. People who experience politically related conflict report 5.6 times more likely to say that their productivity is impacted. It's just something that just really, really impacts them. And on that same line, they're 5 times more likely to report that it impacts their mental health. So it's something that's very taxing and weighing on the minds of people. So we have to prepare for the possibility that in your organization between now and the election, or between the election and the inauguration, or beyond that there may come times when these conversations may rise to a level that cause some challenges in the workplace. So, we often hear people say, well, I can say whatever I want to say because it's First Amendment right. I can say whatever I want to say anywhere. But Lori, is that always the case? Does the First Amendment apply to a private employer? What do you think?
Yeah, so I love this question. And please understand that we are talking about this from an educational, trying to support you as employers. So anything that we say, do not assume that we have a particular political view. That's not the point of this.
Right.
But I have to say that because, oh, but we thought this was a hot topic back in the day. You all may remember when the quarterback, Colin Kaepernick, started kneeling at NFL during the national anthem at NFL football games. And everybody, not everybody, but there's a lot of dialogue about it. And people had very strong feelings about whether they should or should not be able to do that. And I always love the Google JD folks who, pipe up on Facebook and are like, yeah, but First Amendment. And I'm like, okay, putting aside whether or not we think that Mr. Kaepernick should have the right to protest or not in the context of his employment, it's not a First Amendment issue because he's employed by a private employer. So I'm actually really sad that we don't have I'm Just a Bill and other Schoolhouse Rock programs anymore, or that we don't really teach civics in school, because we are really, as a people, I think, uneducated about the way our system of government works and the Constitution. So the Constitution, my history buffs here for a moment. You may recall that when folks came from England primarily to the United States, they did not want a monarchy. Part of the issue was they did not like the way the government worked in England. And so the Constitution and the Bill of Rights was drafted in large part to install protections against authoritarian or monarchy type governments. And so those restrictions include in the First Amendment. And the First Amendment restricts the government from censoring speech. It doesn't apply to private employers. Now, that said, if you are a school district or other public employer, and you might not immediately assume that you're a public employer, but if you are a public employer, then the First Amendment does apply in your workspace, and there are analyses for when and how you can or cannot restrict speech. Generally, employees have the right to give their own viewpoints out of the context of, if it's a matter of public interest. There's a lot of different, but I'm not going to spend a lot of time on it, but there's a lot of different criteria that go with public employers. But for private employers, there's no real First Amendment protections, which means, in theory, you can't talk about it rule at work. We'll talk about whether that's a good idea in a minute. That said, in particular, with respect to the current political climate, you're seeing a lot of overlap with things that people believe to be discriminatory or harassing. Again, we can talk about the conflict in the Middle East with Palestine and Israel, and the various, the different political views on the way that is supposed to work. But, there is a rise in anti-Semitism. There have been, protests, as we've seen in the news. And so anti-harassment or discrimination laws might apply to what we would maybe at first think of as political speech in the workplace, depending on the context of that conversation. And then similarly, here's that National Labor Relations Act again. What does this have to do with unions? Well, the board's current position is that there are certain topics that are inherently protected. And that includes certain aspects of discrimination, of things like the Fight for 15, right? Which we don't get as much publicity about that now, but back, a couple of years ago, Fight for 15 was all over the place. Well, if somebody is speaking about a party and their support for the Fight for 15, and we say can't talk about that, well, talking about the Fight for 15 is probably considered protected concerted activity under the National Labor Relations Act, and we would be violating Section 7 of that statute if we put in a don't talk about stuff. So there are laws that, and you might have policies in your handbook about civility, about workplace respect, all of those things. So these legal considerations are out there, which leads to the question of, my grandmother, she didn't actually say this, but this would be something a
I'm
grandmother would
waiting to
say.
hear the answer. I'm waiting
Yeah.
to hear what that is.
Don't talk about sex, politics, or religion in public or polite company, right? And the funny thing is, and Alison, you've heard me say this, when people say, what do you do for a living? To me, I say, I get to talk about sex, politics, and religion for a living. And I say that because if I say I'm a lawyer, I get subjected to like tons of really bad jokes. But it's a little bit more interesting. So, but the question is, I mean, this, and Alison, I think this is the conversation we want to have, and we would really welcome folks to contribute in the chat, and we can integrate you into our discussion about this. Should we then just have a policy that says basically don't talk about this for the next month or even after, because I can't imagine that this is going to end quietly after election day. We're just not going to talk about it, and that'll just solve everything. Should we take advice from my grandmother? What do you think, Alison?
Well, I think part of this is going to depend on where you live. So there are some states, this is an interesting map that you can access on the SHRM website, by the way. It's an interactive map that shows the private employee speech protection statutes by state. You can see some have none, some have some have broad protections and others, and you can hover over it on the site and see what they are. So I think first of all, you need to know where you are and what rights are there. And with regards to what do you tell people to do? We can tell them not to say anything, but people are going to have conversations. So that's probably not the best approach, but making sure that conversations that are had that may touch on some of these other protected areas that rise to the level of making people feel uncomfortable or intimidated, or some of the other thresholds that might kick into the discrimination or harassment rules are managed. And you as a manager or leader have to make sure that you are enforcing the policies that you do have in place in your organization, whether it's code of conduct, whether it's anti-harassment, etc.
Can you go back for 1 second, Alison?
Sure.
I want to, for example, California specifically identifies political, I forget the phrase they use, but it is one of the protected categories, your political affiliation or I can't remember the word that they use, but it is the same as race, gender, disability. So for those states, you can't take action against somebody for expressing their political views at all. We did talk a few minutes ago about a couple of as Alison said, where they overlap with other areas of law. You might be treading on thin ice if you try to take corrective action. And I think the ones that are going to be most complicated, Alison, are the ones where somebody's speaking about one of these areas that's intertwined with politics, but has some level of protection.
Right.
Their discussion about it is, we'll say, so animated that now we're encroaching on the other employees' rights to have a safe and harassment-free or non-hostile workplace. So.
Right. So I think for anyone listening today, you want to make sure that you take a look at what you have in place. And if you haven't already, and it's always good to remind people of policies or review policies periodically, just remind people of what policies are in place. And if there's something to be created and not necessarily specific to politics, but if you want to have some sort of statement in place or how we're going to discuss certain things, think about that. Lori can share her thoughts on that in a little bit. But whatever policies you do have to be communicated, effectively. Think about it. Many people in your organizations probably signed your handbook when they started with you 10 years ago, 5 years ago, 3 years ago. And of those people, I'm not going to speak for your employees, but I don't know how many of them actually really read the handbook when you gave them the handbook. So that's why we say periodically it's great to remind people of the anti-harassment policy if it's on an annual basis, just as a reminder that there is a process in place, there are guidelines in place, and there's a way to report complaints or concerns so that people have they have the information they need to be able to discuss things or bring things to a manager's attention that are making them feel uncomfortable. The other really big piece of this, and Lori, I know we've talked about this a lot, you can have the best policies in place and they could be communicated effectively. You could send them, you could talk to them, they're posted. But if they're not enforced consistently across departments or across an organization, then you're opening your organization up for risk. So managers have to be well trained. Staff needs to be informed of what their rights are, what managers' responsibilities are. And managers have to be able to step in to perhaps calm a situation down or to redirect a conversation back to the work and away from whatever the topic may be if it's creating an uncomfortable work environment. The other big piece is knowing how to report issues or concerns so that if people are feeling intimidated or uncomfortable or just generally upset about something, what is that process? Who do they go to? And generally speaking, they can go to, most of your policies probably state they can go to any manager with whom they feel comfortable or to human resources, but that there's no obstacle to them reporting any sort of issue or concern. And Lori, I'd love for you to chime in because I'm sure much of what I just said comes up from time to time in your work.
Yeah, no, I agree with all that. I have to say that, and I know you all hear me say this, and it's like a broken record, but the single most important thing you can do is to train your line supervisors, because their reaction, how they handle this situation, is going to be the best indicator of any potential risk that you might have, liability, et cetera. And also probably best dictate what your workplace culture is, really what your employees are experiencing. Because if they respond, let's say they have a very strong personal political view, and if they're not wearing their I'm a supervisor hat, which they should be wearing all of the time, they might respond from their personal visceral space and exacerbate the situation. So I have to say, Alison, that I'm with you, that I think the single most important thing we can do is to train the line supervisors and to make sure that everybody, I guess I'm very much of the mind right now to say, you're probably not going to change anybody's mind, particularly at work.
Right.
So finding a way to disengage that gives space to everyone is your most valuable skill, I think.
Mm-hmm. I want to underscore something you said about the supervisors and managers. When I think about this topic, political conversations, newer supervisors or newer managers just yesterday or just last week were probably having these conversations with their coworkers, the very same people that they're leading today. So someone may be aware, a direct report may be aware of someone's political tendencies, but to remain neutral, now that you're in that role, you really need to be neutral. You don't want anyone feeling that they would be treated differently simply because they have a different political belief than you do.
I don't want to minimize. I mean, we say this, and I sort of sense there are folks in the audience who feel super, very strongly, very passionately about these things, and it's, to a lot of people, it's not just politics, right? And we understand that, but we need to find a way to keep your organization functioning, and so we have to sort of come back from that position and try to put it back in it's just politics, even though it's really not for a lot of people.
Yeah, and that's where the emotion comes in. There's some very real feelings here. You can, again, you probably have policies in place that address much of what we're talking about, but including language around respectful and harmonious work environment, free from harassment of any kind, is something that you want to make sure that people are clear on. And again, that said, things like respectful communication, we can't underscore enough the fact that if you're going to say respectful communication, then as the supervisor or manager, you have to address issues where communication is perceived as being disrespectful or is in fact disrespectful. Uh, we talk about safe spaces, not necessarily in a policy, but at times like this, when people are very emotional, there may be times when you want to be able to just have a safe place where people can go away and diffuse perhaps or step away from a heated conversation. And then lastly, that reporting and enforcement piece, so important, so critical. And please, please, if there are complaints about how somebody feels, take all complaints seriously. We have seen, and in recent history, uh, people filing complaints and maybe another complaint on top of a complaint, and an employer may not respond in a timely manner or might not take appropriate action, and the perception is that it wasn't taken seriously. It may have been taken seriously, the employer just wasn't sure what to do, but making sure your managers know what the reporting process is, what the employees know what the reporting process is, and that the managers follow it. If they are put on notice that something has happened, that they take action, whether that's contacting human resources or their manager, but that there's some action taken to begin to remedy the situation. Lori, do you want to add anything here?
No, actually, I like the sample policy language because it well, I want to see the rest of it, but it can't, we have to be careful about a blanket restriction. As I said earlier, we can't really listen to my grandmother. That wouldn't work well, but I do like the inclusiveness under the policy, the bullet points that you've um, included there.
And certainly for those of you listening, both Lori and I are available to help you work through this and to think through your policies. But again, look at what you already have in place. Maybe you're tweaking some of the language, or maybe you're just reiterating or reintroducing a policy in place. We can say for sure that we do know that things will heat up over the next 28 days and then some. And it's important for you to make sure that you have established and enforced clear guidelines on respectful communication in the workplace. We want to remind everybody to train your supervisors and managers on the importance of staying neutral through times like this. And I feel like we say this every single webinar that we have. Train, train, train. Don't think that just because you gave them training a year ago or 3 months ago, that there's not a moment to refresh.
Can we just pause for a moment there? Because I have, and I'm sure you do too, countless conversations with um, either HR professionals or someone in a position in leadership in their organization who gets the value of what we're talking about, but they are working with a group of executives or leaders who kind of go, yeah, training would be nice, but they don't prioritize it. And I talked about, for example, I gave you some good hard numbers that those folks tend to pay attention to when it comes to doing a wage and hour audit, right? If I can save the company $4 million by spending a little money now and doing an audit, that seems like a good idea. How do you work with, I mean, I have some thoughts, but I'd be curious, how do you help the people that you're partnering with sort of educate the powers that be that sometimes aren't entirely on board?
Well, I think, you bring up a good point where you can quantify impact of lack of training or something that I think about just general anti-harassment training. Some organizations do it every year. Some organizations kind of wait until something happens and then they're told by their attorneys that it's a remedy. Well, they probably spent a lot of money when to be told that they need that as a remedy. So proactively speaking, where are your vulnerabilities? If your managers and supervisors are well versed in what their responsibilities are in upholding the policies and processes of your organization, you'll be in better. It's worth the time and the investment on the front end to prevent what will happen on the back end. It's just really a matter of time. So where you can quantify that in legal fees, in time to do investigations. I mean, you can see organizations that are constantly doing investigation after investigation. There's probably some work that could be done proactively to train managers to reduce the number of investigations. If they're handling situations more effectively, it is less likely to rise to the level of investigation. And investigations take time and resources. They're expensive. So I think when you're trying to make the business case to your organizations, figuring out how you can tie it to the dollar value and the impact of time, which is your manager's most valuable resource, and they don't have enough of it, that's going to help you make that business case. Lori, I don't know if you have any other suggestions there.
No, I mean, I think if you have to know who you're talking to, right? So if you're trying to sell it to the chief financial officer, although I have some good friends who are in that space who also recognize the value of HR. But if we're talking about somebody who's sort of numbers oriented, go in with a plan that says, a one discrimination lawsuit could cost you with just to defend it a couple $100,000. And if you lose, have some verdicts or things like that. Those tend to be some selling points. The stuff that really I think people find frustrating is to spend an hour or two doing training, even on this stuff. What's not quantifiable is the manager's heightened ability to kind of keep things calm rather than think about the amount of time some organizations are losing right now because people are having these arguments and discussions and then they're distracted. And you talked about earlier in the session about the impact on some people and their ability then to work. Whereas if we took what is that, an ounce of prevention is, I never get that right, but
yeah,
is worth a pound of cure or something. It really is. It's one of those situations. But I've had several conversations recently with people who are like, I'm totally on board, but I can't sell it. So I thought it was worth, for the amount of times we stress how important training it is, I wanted to be able to give some of our folks some tools.
Yeah. And you just made me think of something that you said just prompted me to be reminded. When we talk about this communication in the workplace too, remember, it's not just face-to-face communication. It's communication on your Slack channels and your chat features. You have to be observant as the employer to make sure that if something is going in a wrong direction, that it is addressed and it is corrected so that it doesn't, you're not giving tacit approval that type of communication is okay in your workplace. So that said, we open the floor to any questions that you may have. And Lori, can you see the feature? Because it's not showing on my.
Yeah, I don't have anything in the Q&A. There's not really a ton in the chat either. Would love to hear from some of you about if there's any scenarios that you've had to deal with or things that you're particularly concerned about in navigating the next month or so as we're in election season.
Of course, we know that post-election we'll have a whole slew of things that we can talk about depending on
Yes.
the way things.
Well, and I would say then as I guess we'll wrap up a few minutes early today, but let me say this, that our next session then will be post-election, and we can at least spend some period of time talking about what we can anticipate coming in 2025 on the labor and employment front. And if there are topics, while we have folks here, that you particularly be interested in hearing, please put them in the chat so that we can include them in our next conversation with you all.
And if we don't hear from you now, we want to make sure you have our contact info. As I said in the beginning of the session, What's most important is that we address your questions. That's why we put this program together however many years ago. We're not really sure. We think it might be 5 or 6 now. We think it was pre-pandemic. But we really hope that you found this time of value, and we hope to see you at our next session, where I'm sure we'll have lots to talk about in the next environment. So Lori, on behalf of everyone at Exude, thank you so much, and everyone at Fox Rothschild for allowing you to spend time with us. And to
And
all,
as we sign off, I see there's a couple questions. If you have
okay,
because we're going to sign off, feel free to reach out to me directly. I'm happy to talk through any questions that came up as a part of our discussion today.
great. All right. So we will see you on our next session. Thank you all.
Thank you.